Senate Bill 1 by Senator Fields now moves for suspension of the rules for the purpose of taking up the bills, reading them the first and second time, and referring them to committee. Without objection.
Without objection.
Senate Bill 1 by Senator Fields is an act to amend Title 18 and to repeal certain sections of Act 5 of the 2022 First Extraordinary Session relative to congressional districting, to provide for the redistricting of Louisiana's congressional districts, referred to the Committee on Senate and Governmental Affairs. Senate Bill 2 by Senator Hewitt is an act to amend Title 18 and to repeal certain sections of Section 5 of Act 5 of the 2022 First Extraordinary Session of the Legislature relative to congressional districts and to provide for the redistricting of Louisiana's congressional districts. It is referred to Senate and Governmental Affairs. Senator Hewitt now moves for suspension of the rules for the purpose of allowing the Senate Committee on Senate and Governmental Affairs to meet tomorrow without the required 1 p.m. posted notice.
Mr. President,
Senator Fields on a point of order.
I press my point of order. Does the bill by Senator Hewitt create 2 majority-minority districts?
I'm going to check with the Secretary. I have not read the bill. It just was introduced.
Does it comply with the court order, and does it have
My understanding from the author and from the Secretary, they do not believe that it does have 2 majority-minority districts as it's filed.
Then I'm going to object with the suspension of the rules, because if it doesn't comply with the court order, there's no need to send a bill to the committee. Object.
Okay, members. Senator Fields, you're objecting to sending all bills? Okay, state your complete objection so that...
Sir, Mr.
your
President,
motion.
Senate Bill 1 is already in committee. I'm objecting to Senate Bill 2. We're on a short circuit here. We only have 6 days. There's no reason to send a bill that does not comply with the court order to committee. We're here to comply with the court's order.
So I'm told the motion was for both the bills to be to suspend the rule for both the bills to be referred to committee. So if the objection is for both of them...
No, sir, Mr. President. My bill was sent to committee. I objected on sending Senator Hewitt's bill to committee. We are on Senate Bill 2. My bill has passed that process.
Okay, your objection is because as it is originated, you believe it does not comply with a court order.
Not that I believe. If the bill does not comply with subsection 2, which creates 2 majority black districts, it does not comply with the court's order.
Okay, what I'm being told is that in general it does comply with the objects of the call, and the legislature is free to legislate on any instrument that complies with the call.
That's not my... I'm sorry, Mr.
That is to legislate with regards to congressional districts.
And Mr. President, with all due respect, that is not my objection. My objection is her bill does not comply with the court order. We only have 6 days. It makes no sense to send a bill to committee that does not comply with the court order. Her bill only creates 1 majority black district, and I'm objecting to suspending the rules on that basis.
Okay, objection noted. Senator Fields, we're going to take a vote on your objection, but before that, I feel compelled to notify the Senate, the full Senate, that if somehow a bill were to be amended that was no longer in compliance, I think a motion in order to remove it from the files of Senate, namely if Senate Bill 1 were to be amended in Senate Governmental Affairs and reported to the full Senate, I think that by virtue of this, there could be a motion to remove your bill from the files of the Senate. I don't know that we want to get into this. The idea of the Senate Governmental Committee or any committee in the legislative process, the purpose is to vet the bills and to offer potential amendments. I don't want to speak for the author, but I think everybody has read the call. And so at this point, I'm going to allow Senator Luna to make a point of order, but we're going to dispense with his motion, Senator Luna, unless your point is about his motion. We're going to dispose of his motion. Would you like to make a statement before? Okay, will you yield?
Mr. President, it's not on the bill's not on the computer yet. I'd like to see it and see what it looks like before we vote on that motion if we could.
Okay. Okay, so Senator Luna, I'm told that until a bill is introduced and gets a number, they don't put it up, but I'm being told that it's being put up as we speak. Senator Luna?
Thank you, Mr. President. Members, I object to this as well, and for the same reasons that Senator Fields did, but also we're voting on an instrument that we hadn't seen yet. That's not a good idea. We need to at least see this instrument and see what it's at, because I do agree that if it doesn't meet the objectives of what the court has told us with 4 different judges now, that's problematic. So we need to at least be able to look at it.
So at this point, we have an objection to the suspension of the rules for the purpose of referring Senate Bill 2, I think it will be, to the Committee on Senate Governmental Affairs. Is there any objection? Well, the motion has been made and there's been objection. Senator Hewitt, do you want the floor on the objection?
Thank you, Mr. President. Members, as we know, there are no guarantees that a bill, the way it's introduced, is going to look that way when it's done at the end of the process. And so, there's no guarantee Senator Fields' bill is going to look the same, and there's no guarantees that my bill will look the same. But we are here to adhere to the court order. And so that would be my intent. Having said that, I will say that if you want to let the bill lie over, Senator Luna, so that you have an opportunity to see it, I would be happy to do that.
Okay, so Senator Price, do you have a question? Okay. Okay. So Senator Fields has made a motion to which he objected to, and so now at this point, the vote is if you're in favor of suspending the rule, you will vote yay. If you're opposed to suspending the rule, you will vote nay. And the secretary will open machines. Okay, you through voting? Close the machines. 0 yeas and 30 nays, and the rules have failed to be suspended. Senator Hewitt's bill will lie over. Okay. Senator Peacock, you have a point of order?
Thank you, Mr. President. But the motion was on both, the rules were suspended for both bills, correct?
Yeah, the initial motion was made by the Secretary of the Senate on behalf of Senator Fields. Senator Fields came down and made a clarification on the motion. It was his motion. He clarified that his bill was in committee. The motion that was made on his behalf by the Senate Secretary was to start the process, as we do every session. We read bills on a first and second reading to refer them. We do that traditionally. The first bill, the author of the first bill is generally the one that makes the motion to suspend the rules for all bills. In this particular case, it happened to be Senator Fields. He had Senate Bill 1. When Senate Bill 2 came up to be referred, he objected, and I'm going to deduce that he bifurcated his motion to say that his motion was to suspend the rules for Senate Bill 1, but objected to the suspension of the rules for Senate Bill 2. Senator Fields, if I'm misstating your point, please come down and clarify. Senator Bear,
At this point, I'd like to reconsider the vote on the suspension of the rule on Senate Bill 1.
okay, so at this time, Senator Peacock has made a motion to reconsider the motion to suspend the rules on Senate Bill 1. Is there any objection? Senator Fields, state your objection.
Point of order, Mr. President. Senate Bill 1 does comply with the court order, and it does create 2 majority districts, does it not?
I haven't read the bill, but I
Object.
Senator Peacock has made a motion to reconsider the vote by which the rules were suspended in order to refer on second reading Senate Bill 1 to Senate and Governmental Affairs, to which Senator Fields objects. When the machines are open, a vote yes is to reconsider that vote. A vote no is not to reconsider the vote. And the Secretary will open the machines. Vote your machines. You through voting? Close machines. 18 yeas and 11 nays, and the motion has been reconsidered. Senate Bill 1 will lie over. Senator Fields for the floor.
Mr. President, members of the Senate, now we're here today for one purpose, and one purpose only. And that is, we've been ordered here by the courts to draw 2 black or minority districts. And there is one bill that does that. And we're on a 6-day period to do it. And we have had sessions in this Capitol where we have passed bills in 6 days. So we can't say we can't do it. We can say we don't have the will to do it, but that's by choice, not by obligation. A rule is a rule. And we can suspend it anytime we get ready, just like we just did. We make them, and we suspend them, just like we did. Now, not one judge, not 2 judges, not 3, but 4 federal judges just told Louisiana to do what we just said we're not going to do. We just told them we are not going to do it because we can. We the big legislature, state of Louisiana. You don't tell us what to do. In 19, I think it was 90, we had a session where we had to draw lines, and we did it in 8 days, but we took 2 days off. So technically, we did it in 6 days. We had an appropriation for corrections that same year, and we had a session in 6 days. Let's talk about rules. Rules are made to be suspended. If you suspend a rule here and you take a bill, no one can say it's unconstitutional. No court will hold a bill passed by this legislature unconstitutional because we suspended a rule. Just say we don't want to do it. 6 members of Congress, over a third of this state is black. Just say we don't have the will to do it. Has nothing to do with Republican or Democrat. It has everything to do with right versus wrong. You got the votes. You got the majority. Senator Peacock, you gave it to me. You won't let that bill go into committee? Then I won't let your bill go in committee. Because I got the votes. And I'll show him. What has this state come to? Is that the way we do business? Is that what we're about? I'm in the majority. I don't care what you think. And I certainly don't care what those judges think. We're going to do what we want to do. Now, we're going to lose this day because we can. Now, Senate Bill 1, it's been on the calendar for 3 months. It was Senate Bill 306 this past session. And then during the special session for redistricting, you saw it then. It never changed. I argued it here. I put it up as an amendment to Senator Hewitt's bill. It's nothing new. One out of 6. And that's just the way it's going to be. Until some higher court, higher than the Fifth Circuit, tell us different. Aren't we better than that? Now, Senator Hewitt, I know you are. You traveled all over this state, holding town hall meetings. You heard the people in this state. From Shreveport to New Orleans, you heard them. They said, we want a second minority district. You heard them. Every town hall meeting you held, people said they wanted a second black district. The plan is more compact. It beats your plan on every measure. The president, with all due respect, hired lawyers and not one of you knew about it. The people on the committee didn't know about it, other than the chair, I guess. Now we have lawyers in court fighting against a second black district, and they losing every time. Why? Not because they're not good lawyers, they just can't argue against it. It's wrong. Let me tell you what they do in Congress. I can take a matter of personal privilege. I've been there. They appropriate money, and they send it to the several states. And Louisiana has the second highest black population in the entire country. Black people need to be represented. No other state in this nation has more black people than Louisiana. This body is better than that. We don't need a court to tell us we need to do the right thing every time. It's not about Republican, Democrat. It's about right, wrong. Nothing made me feel worse than when the governor's veto was overwritten. You could hear the shouts in the other body, like someone had won the Super Bowl. Are we not better than that? I don't know what we're going to do this session. I know why we're here. I've read the 100 and some page opinion from the district court and 100 and some page opinion from the appeals court. How many times they got to tell us to do the right thing? We got a job to do, gentlemen and ladies. Now, what just happened, in my view, as a lawyer, is a contempt of court. And now tomorrow, my president and the Speaker of the House has to go to a court and say why they need more time. When they sent a bill back to the calendar that complied with the court order, but we need more time. It's time for us to do the right thing. It's not time to play games. It's time to do what we should have done the first time. I have nothing further to say, Mr. President, and I thank you for the time.
Thank you, Senator Fields. Senator Luno, would you like the floor on personal privilege?
Thank you, Mr. President. Members, I don't think any of us want to be here today. I know I don't. But I'm here today because I have an obligation. When I ran for office and I was elected, I promised to do what I had to do to represent the people of my district and the people of the state of Louisiana, and that's what we're here to do. We have an obligation to do this. We're obligated to redraw these maps because the courts have said you have to. And Senator Fields is right. There are 4 different judges that agreed to that, appointed by, I believe, 4 different presidents. For sure, 3 different presidents. And when they told us to do this, they told us to do exactly what I asked you to do when we were here in the first special session of this year. And that is to make the maps reflect the population of the state of Louisiana, because we are obligated to do that. And we all know that. I'm not going to go through the courts and talk to you about what the requirements are. We all know that. But just a few short days ago, I stood at this mic and I asked you to do the right thing then. And you did. We passed a law that took away some of the last vestiges of slavery in Louisiana from the holiday list. And I told you then that would be a step in the right direction. And you know what? It was a step in the right direction. But we have an opportunity to take a step in the right direction again here today and through this session. And that is to draw legitimate maps that reflect the population of the state of Louisiana. Minority people do deserve the right to elect the people they want to represent them in the legislature. And we have the obligation to do that. Let's get to work.
Senator Bowie to the floor on personal privilege.
Thank you, Mr. President and members. I concur with our colleagues, but let me tell you where what we just did puts us. Declaration of Independence says, we hold these truths to be self-evident that all men are created equal. That's what this piece is about. That we afford to every Louisiana citizen, based on numbers, the right to be represented. And so what kind of Louisiana are we trying to build for our children and grandchildren and great-grandchildren? We want vestiges of discrimination and denial to continue. I'm very disappointed in what we just did. Thank you, Mr. President.
Thank you. Senator Jackson, personal privilege.
Thank you, Mr. President and members. Members, I've read the court opinions. We all advocated for what at the time we thought was right, I assume, or what I'm finding we thought was politically expedient for some of us. When we redraw maps every 10 years, they're not to be drawn on party lines or to preserve a status quo, but to fairly draw maps that represent all people. As a black female that sits in this body right now with one other black female, a limited amount of minorities, although we make up 1/3 of the state, congressionally, we make 1 out of 6. For me, it has always been simple math. Dr. King said that a right delayed is essentially a right denied. As we sit through these next 6 days and on the first day of session, we've delayed the right of a people to be properly represented, the right for our state to have fair maps. I believe when we come here, we represent people, not ourselves, not our party, but people, the population of what we call, what I believe to be the great state of Louisiana. But I'm going to submit that if we don't do what we've been ordered to do, then this state remains great for some while remaining somewhat of a disappointment for others who constantly ask for their rights not to be denied, to have a fair seat at the table. For 1/3 of population who pays taxes, for 1/3 of a population who works hard, for 1/3 of a population who has the same hopes and dreams for their children as everyone else has, to be fairly represented. So I came here to do the business of the people, not the business of a party, not the business of what my personal belief was, but the business of the people. And that's always fair representation. I am hoping after what just happened today, we get there. And we realize that delaying anyone's right is truly denying that person's right. Thank you, Mr. President and members.
Thank you. Senator Barrow for the floor on personal privilege.
Good afternoon, Mr. President and members. Here we go again. As many of you know, oftentimes when you see me, I have on this one pen along with our state pen, and it says one word: vote. Voting is the one equalizer that each of us have one of. And at this point, it appears that we are denying the people of color, people that look like me, the opportunity to have the choice to elect a candidate of their choosing, because we will not draw a map that can give them that opportunity. I know last time I came up here, I talked about my own personal stories and things that I had gone through and things that I have experienced that honestly, Peacock, I hope my children and my grandchildren never experience. Fairness, to be able to buy a home where I want to, and not have redlining as a part of the issues that we are conflicted with, because I have representation, Womack, of somebody who understands the plight of folks that looks like me. So I'm asking you, members, really I'm pleading with you and I'm begging with you. The measure that we just took now seems like we may not get there. But I'm hoping through the end and before the end of this process, while we're spending all this money, for the attorneys that we have, and the time that we are here, that we come out with a product that the courts have already told us we have to do. Let's do our own job and not have the courts have to do our job. Thank you, Mr. President.
Thank you. Senator Price, the floor, personal privilege.
Thank you, Mr. President. I sit on S&G, and I went around this state, and I made every meeting we had, every community, every town hall meeting. And in each of those meetings, people got up and said we need fair and equitable maps. Not just people of color. It was people, it was citizens of this state that made those statements. And I felt then that it was falling on deaf ears. Because when we came back to committee, and I mentioned this in one of the committee hearings, that we did not listen to what the people were saying around the state. Everybody talked about the fact that this state in the black population has increased 1/3, and we needed fair and equitable maps. But what did we get? We had to get a court to come back and say, you didn't do the right thing. And today is an example of pleading and what our citizen has said to us to do the right thing, falling on deaf ears again. And why? Why are we here? Why are we not listening? Why do we have to have a court to tell us what we have to do if we're going to do the right thing? Why can't we do the right thing? Many of you went around the state with us. Many of you heard it. But yet and still, we returned and we did something that the people of this state say that we should not do. Because why? And I understand the process. Let's maintain control. We are in control, so let's maintain control. But that's not always the fair thing to do. It's not always the right thing to do. Politically, it may sound great. Yes, let's do it. But what do we do? And what do we do in the sight of God? What type of people have we become when we won't do the right thing? We won't even try to work together to do the right thing. I look above and I let him guide me. And he will guide us. And at some point in this world, I pray every day that we do the right thing for each other. Thank you, Mr. President.
Thank you. Senator Hewitt, the floor on personal privilege.
Thank you, Mr. President. Members, this legislature has the constitutional responsibility for drawing districts, and we've done that. We were here for 19 days in a 3-week session, and 2/3 of us determined that the map that we passed was the best representation of the state of Louisiana, and we did that. We spent months before that on a road show. This was the most public and transparent process that we've ever had. We made sure that when there were amendments put on these very complicated bills, that members had an opportunity to understand them. The public had an opportunity to weigh in. And we're going to continue to do that in this process. Now, you talk about doing the right thing. We did the right thing. We deliberated as a legislative body and passed a map. We did what we always do, right? People get to debate. The public gets an opportunity to weigh in. And we did our job. Redistricting is not an easy thing. You have to thread the needle between the Voting Rights Act and the 14th Amendment. The 14th Amendment says you cannot use race as the predominant reason for drawing a map. Yet we're being directed by the court to use race as the reason to draw a second district. But here we are. And although maybe there have been bills or maps that have been passed before my time in 6 days, I think it is extremely difficult to do that without sacrificing transparency and the opportunity for public input. But we are here because of a court order. And we will continue to do the job that we are all elected to do, and that is to represent the people in our district. And I'm committed to doing that, and I believe that you all are committed to doing that as well.
Thank you. Senator Carter, the floor on personal privilege.
Thank you, Mr. President. Members, I read the Middle District Court's opinion, and I encourage all of you to read it as well. It's 152 pages, but it reads fast. And not only, one of the things that's fascinating about the opinion is the judge just doesn't rule that we should create 2 minority districts, but the court explains why. And the court explains the long documented history of discrimination against African Americans right here in the state of Louisiana. And one of the things that's fascinating about that opinion is that the defendants in the case conceded Louisiana's long discriminatory history about discriminating against African Americans in the state of Louisiana. It was conceded that Louisiana has this long documented history of discrimination. That's fascinating to me. It's fascinating to me because we're debating, during a regular session, concepts like critical race theory that makes it improper or inappropriate for schools to teach Louisiana's discriminatory past. And yet it was conceded in the district court that Louisiana has this long discriminatory past. And I have in front of me, I know it's on my screen and I don't even have my glasses on, but I'll show you, it's the US Constitution. And when we formed our United States Constitution, the most important branch of government, all of government, according to many legal scholars and historians, is the United States Congress. That is why it is established in Article 1, Section 1 of the United States Constitution. Article 1, Section 1, all legislative power is hereby vested in the legislative branch, the Congress, which shall be conformed of a Senate and the House of Representatives. It defines the Senate a little later on. Each state shall get 2. But how our nation was founded, how it was formed, how it came together was all about how do you determine the appropriate number of representation of the members of Congress, the members of the House of Representatives. The same thing we're going through now. How do we apportion representation? How do we district ourselves? And you look at the original text from their Constitution, Article 1 establishes Congress. Article 2 says this is how we're going to go about establishing the House of Representatives. It provides the minimum age requirements. It provides the citizen requirements. And then it gets to how do we apportion them? And you know what it does? It considers my ancestors, African Americans. When it comes to counting us, you just count them as 3/5 of a person. It's embedded in our original Constitution. African American slaves, we shall be counted as 3/5 of a person when trying to figure out how to draw the maps, how to apportion the original House of Representatives. I mention that because not only does the state of Louisiana has a long documented history, uncontested history of discrimination, but so does this nation. And it continues today, not just with our founding, but we have a federal judge right now pointing out to us our discriminatory practices. It continues. And I must tell you, I dealt with critical race theory when I was a member of the Education Committee on the House side. I'm so much happier to be on the Senate side. It's much smaller. It's less of us. We really get to talk and get to know each other. And you're hearing from each and every one of us, the individual members of the Black Caucus. We're telling you how Democrats, not just African American legislators, but how personal this is. How offensive it is that we have this long documented history of discrimination in our state, at the nation. We have federal courts, appellate courts telling us, reminding us to stop discriminating, to do what's right. And yet here we are, we find ourselves doing it again and again and again. It has to stop. Please let it stop. Let's move forward together, please. Thank you, Mr. President.
Thank you. Senator Boudreaux for the floor, personal privilege.
Thank you, Mr. President. Members, I rise. I know sometimes it's uncomfortable when you have these type of conversations. I've spoken on a number of occasions about the Senate and the institution that we are so privileged to serve in. And if we just go back on memory lane just for a minute historically, the numbers in the 60s and the 70s were predominantly Democrats in this place. Senator Fields talked when we were in the redistricting session about the number of African Americans who have ascended to Congress. So while it's uncomfortable to sit, we in this institution have an opportunity to change this. You know, Senator Bernard, you served in local government. You understand where the rubber meets the road. See, our actions will trigger reactions to so many other things in the community. Now, let's just go back to the simple math. 6 congressional seats, and there's 1. Just simple math. When the ask is for a second minority district, which would still be 2 out of 6, is that unreasonable? Is that distasteful? If we don't do it, then who's going to do it? So we talk about the courts, and we say, let it go to the courts, and it's going to the courts. It reminds me of the presidential election that ended up in the courts with Al Gore and President Bush. He said, let the courts decide. And what did Al Gore do? At the end of that exhaustive process, he said, it's over with. President Bush is our president because the courts decided that. We have people today who still believe the last election was a big lie. They haven't accepted the fact that we do have another president. But you see, that's where we come in. We have to change that narrative. But if we go around with that same rhetoric, we go around and saying, well, that court missed it. They didn't get it. We got to show respect to the courts when you win it and when you lose it, and be graceful in defeat. Now, I'm not holier than anybody else in this room, but I believe in the power of prayer. And I'm going to continue to pray that the courts continue to be consistent in their rulings. That's still not going to bring everybody where they need to be. But you know, we open in prayer every day, and I try to close my eyes because I got to take care of me. And that's why I'm up here today. Each and every one of you know what is right. 2 out of 6 is not anything. I mean, simple math. I said it when we were in redistricting. If the African American population went down during the census count, hell, we'd be up here fighting because we wouldn't have 1 seat. Senator Carter just talked about 3/5. It'd be down to 1/16 of a vote. And I'm not being sarcastic. I hope you understand that this body, this deliberative body, the Senate, if we're just going to wait and keep saying, well, that court's got it wrong, and let's appeal it. See, I prefer to take that money. We did a lot on roads and bridges throughout all of our districts, but I got some people back home. They still at minimum wage. And when we look at this whole process and the amount of dollars that's spent to either defend or to send out false information on where we're going, we control that. We control that. So I'm going to ask you, you know, my years of officiating, first couple minutes of a game when the ball doesn't go in the hole, Coach Pope, it's going to be a long day. I have a bad taste in my mouth for how we just started this short session. It doesn't taste good. It doesn't feel good. I'm glad it's not me that have to go to court tomorrow. I don't know what to say. I don't know where we at. I think we're in a bad place. I think we need to hit the reset button and decide what is it we want. We talk about what we want for our kids and our grandkids. We talk about how great this is a place to live in. Be with those people who don't have any contact with their congressman. Be with those people who feel that they are left out and not listened to on any fronts. Listen to them. And if it doesn't trigger anything, I can't help you. But I can tell you, I hurt for those who don't have a voice. I hurt for those who as Senator Barrow said earlier, they got a rent. You know, people say, well, they in that situation because they put themselves there. Okay? Okay? Just keep believing that. Just keep believing that. I'm going to ask. We're off to a bad start. Now, there's been some teams win the Super Bowl. I think somebody alluded to the Super Bowl. Some teams have won it, and they lost their first couple games, and boy, they hit a streak. We got to hit the streak. We got to do it for our people. We have to do it for all of God's people. We got to do it for the state. You know, we said before, do we want to look like Washington, D.C.? Is that what we want? Dysfunction? Nobody wants to be here to address this, but by God, we raised our hand and we took that oath. Let's take care of the people's business. I won't be here when the pendulum swings and more people are in the people that are in the minority today will be in the majority. But I hope they'll be like Al Gore. At the end of the fight, it was a good fight. I would hope they'd be like John Lewis and go and fight for all of the people. We quote Dr. King often, but do we walk in those same paths, along that same trail that he walked up until his death? And that's about service. Let's take care of business. Let's hit that reset button today and decide we got to let the courts tell us what to do. And then when they tell us, we don't listen. Let's see where we're going. Thank you.
Thank you, Senator Boudreaux.
President Cortez to the floor.
Thank you, Senator Talbot. Thank you, members, for being here today, taking the time out of your life to come back to this beautiful capital that we get to serve in. I want to kind of bring you up to speed as to how we got here, a little bit of background on why we're standing here today or sitting here today. There was a couple of people that alluded to legal firms. I want to remind you all that there was a lawsuit brought against the state of Louisiana before we ever filed a map. I'm going to repeat that. Before a map was ever filed, there was a lawsuit brought against the state of Louisiana. As the presiding officer of the Senate, it's incumbent upon me, whether I like it or not, to support the will of this deliberative body. I can be on the losing side. I still have to support what the body said. I don't have a choice. If it's 20-19 and I was one of the 19 and the 21 and someone sued us, I have to support the 20, even though I didn't like it. And even though I disagree with it. I'm going to give you a little timeline. On June 6th, the last day of our legislative session, you all recall, a federal district court judge issued an injunction against our congressional plan that we had passed in our extraordinary session from previous. That same judge also directed the legislature to prepare a remedial plan by Monday, June 20th. I don't know if the judge knew what it would take to get us into a special session or not. That's not my job. I don't want to question a judge and their knowledge of the legislative process. That's what they do. I don't know what to do in a court. Never been in a court before. Tuesday, June 7th, the governor issued a call for a special session to start today, June 15th, and to end Monday, June 20th. Now, the governor has the control of the call. He could have said it could end June 25th or July 1st. He didn't. That's his decision. I say this many times. I try to do what we do on the first floor. I don't try to dictate what the governor does on the fourth floor. That's his job. He runs the executive branch. We've got co-equal branches of government in our democracy. On June 9th, Thursday, the Fifth Circuit stayed the lower court order pending a briefing on the stay. Now, again, for those lawyers here, you're going to maybe correct me later, but what they were saying was, we're going to stop this process until you can come talk to us. At which time some motions were filed, and the three-judge panel at the Fifth Circuit issued a ruling. Their ruling was, we're not taking up the merits of the case. And by the way, Senator Carter, you read the 152, I did too. It was a very good read, and so was the 30-something page Fifth Circuit. They said, we're not taking up the merits today. What we're saying is that there's enough information, y'all should go into session and honor the fact that the district court said the first opportunity to remediate ought to be with the legislature. On Sunday, June 12th, the Fifth Circuit lifted their stay. I can tell you, and I talk to people on all sides of this, many lawyers, some that work on the fourth floor, not one of them suggested that they thought the Fifth Circuit was going to reverse that stay. I had many of you call me and say, is it safe for me to go on vacation? Is it safe for me to take a trip? To which I had to reply, I don't know. I don't work in the courts. If you're taking a trip, make sure you get insurance, trip insurance. This Sunday, they reversed the stay. So, on Monday, the 13th, myself along with the speaker asked the district court, because I could read from the Fifth Circuit, I don't have it with me, but I could read it says both in the district court and in the appellate court, but if more time is needed, the district court would be open to giving you more time. 6 days is a very short period of time to pass a commemoration of Mother's Day being a good holiday. It still constitutionally requires 3 readings on both sides. It still requires a committee hearing on both sides. It still requires, if the two chambers who are separate decide to have a disagreement, you would have to go to conference committee. Very, very difficult to do in something that's so emotionally charged, affects every corner of the state. So, on Tuesday, the 14th, that was yesterday, the district court scheduled a hearing for Thursday, tomorrow, June 16th, requiring that the speaker and I attend to discuss the request for more time. I will say this, the district court did respect the authority of the legislature to offer a remedial plan to the ruling that they laid down. We have all known somebody who's gone to court and gotten a bad ruling. And immediately what they do is appeal it to the next court. We've watched it on TV, walking out of the courtroom saying, "Don't worry, we're appealing. We believe the court got it wrong." We say all the time in legislation, until the court of final jurisdiction determines this shall be the law, or we put that in bills all the time. But I want to read from the court, that the 152 page that Senator Carter referenced. It's on page 2, and it's the early part of it. In fact, when I had a conversation with the governor with regards to this special session, he said, "Page, you won't need to read very far. It'll tell you exactly what's going on." On page 2, in the second paragraph down, it says, "The appropriate remedy in this context is a remedial congressional redistricting plan that includes an additional majority black congressional district. The United States Supreme Court instructs that the legislature should have the first opportunity to draw that plan. Therefore, the court orders," and it's in bold, the court orders, that means that court orders the Louisiana legislature. Now, we are a co-equal branch of government. We are not the judicial branch, and we are a deliberative body. No one can order us to do anything other than to go try to get our job done. But we, neither one of us in here controls this whole process. We're one vote, each of us. And currently we have 143 members. We can pass a bill out of the Senate that would be in 100% agreement with every one of the 38 senators we have elected, and it could not get a single vote in the House. So I want to go on in that order. The court orders the Louisiana legislature to enact a remedial plan on or before June 20th, 2022. Now, that's a terminus that was put in by a judge in a process that judge can't control or has no control over. We don't even have control over it. When I say that, I mean that just what happened here earlier today, a motion was made, an objection was made, a vote occurred. The outcome of the vote was a byproduct of democracy. That will happen throughout this process over and over and over again, and it will happen in 2 different chambers. So Senator Fields was sort of the byproduct of being Senate Bill 1. His name was the name given to that first motion. It was a cumulative motion. We do it every session. The first bill gets read in, we suspend, we read it first reading, introductory reading. Normally the rules tell us it has to lie over to the second day for a second reading and then referred to committee. And then on the third day, it can be taken up in committee, but it doesn't require the chairman to take it up on the third day. Remember, all you chairmen in here, there are some bills that were filed on the first day that you didn't take up maybe till 5 weeks into the session because you had a lot of bills. We have 2 bills, folks. 2 bills, senators. And why would we want to stifle debate on such an important issue by asking either one of them not to be referred to committee? If you believe the order is the order, and if you believe a bill doesn't confine with the order, then it's not going to matter anyway. But if it's a bill that was filed and possibly could take on amendments and be within the context of the order, let it be heard. Don't delay it for another day. So I think we're starting off on the wrong foot. Senator Boudreaux suggested that. I think we need to hit the reset button. And I'm going to remind you that, you know, I love Senator Fields. He is passionate about this issue, as passionate as anybody in this room. What he did by objecting to that motion was to stop discussion of a second bill. So when we talk about when we lose, we want to take our ball and go home. Senator Fields, I'm going to ask you, let's hear both the bills. I'm giving you all day to hear it. I'm giving Senator Hewitt as long as we can. We are going to set the date to return to session as far away from the committee hearing beginning so that all the debate can be heard and as many people as possible could come. We have, you all know, very little chance of passing a bill if we let them lie over tomorrow, only to refer them both to tomorrow, only to have them heard on Friday. So to Senator Boudreaux's point, I'm going to press the reset button, and I'm going to make a motion that both Senate Bill 1 and 2, that we suspend the rules to allow both Senate Bill 1 and 2 simply to be referred to the Committee on Senate and Governmental Affairs. That's my motion.
Thank you. We have a motion to report Senate Bill 1 and 2, to refer 1 and 2 to suspend the rules to refer them to committee. Is there any objection? Senator Fields, you want to state your objection?
Mr. Chair, I've been asked to bifurcate the motion, and I would be happy to do that. I'm gonna make the first motion to suspend the rules to allow Senate Bill 1 to be heard, to be referred, to Senate Governmental Affairs. That's the first motion. The second motion will be, and I know you need to dispose of the first one before, the second one will be to suspend the rules to allow Senate Bill 2 to be referred to Senate Governmental Affairs, to suspend the rules to allow it.
Okay, so we have a motion to suspend the rules to refer Senate Bill 1 to Committee of Governmental Affairs. Any objection? Seeing no objection, the motion is adopted. We now have a motion by Senator Cortez to report Senate Bill 2, refer Senate Bill 2 to the Committee on Governmental Affairs. Is there an objection? Seeing no objection, the motion is adopted. You want to state your, I'm sorry, there is an objection, Senator Fields? You state your objection? No? Okay, we have an objection. So the Secretary will call the roll. A vote, when the machines are open, a vote yes is to refer the bill to Senate Governmental Affairs. A vote no is not to refer. Secretary will open the machine. Secretary, close the machine. 21 yeas, 9 nays. The motion is adopted.
The bill has been referred.
Senator Hewitt now moves for suspension of the rules for the purpose of allowing the Senate Committee on Senate and Governmental Affairs to meet without the required 1 p.m. posted notice tomorrow.
Is there any objection? Seeing no objection, motion is adopted. All right, announcements.